Welcome to Aging in the U.S. Public Health Care Programs. This is your Week 4 video. Week 4, we have discussed Medicare and Medicaid, and we read some materials that talk about what the future of Medicare and Medicaid will bring. Two of the underlying topics in the future of Medicare and Medicaid have to do with waivers and how they work, and the future of the ACA. I really wanted to focus on these two issues because these issues are really pressing in the next 2 years. So first of all, you're going to read a lot about a 115 waiver. What is a 115 waiver? Well, under the Social Security Act, the Secretary of Health and Human Services can basically waive certain restrictions the federal government gives the states. They're allowed to say to the states, you do not have to follow these Medicaid rules if you're doing something experimental, you're piloting a program, or you're figuring out a demonstration project. Now, historically, these were done when states wanted to try out a novel approach to implementing their Medicaid program. Under the Trump administration, we're seeing current waivers that are mainly incentivizing work and community engagement. Basically, work requirements for Medicaid. Now, this is a little bit different than we've seen under the past 8 years of the Obama administration, because 1115 waivers were mostly used to figure out how to broaden that scope of Medicaid services. And there are arguments that the current administration is using these work requirements under Medicaid to restrict the use of Medicaid. So there's a couple of articles that you can read and think about, why do we have 1115 waivers? What do they do? And how can they be used to either broaden or restrict people accessing the Medicaid program in their individual states? The other thing I wanted to talk about really quick was what's happening with the Affordable Care Act. You might be seeing in the news currently that the Affordable Care Act was ruled unconstitutional. So what happened was, in December of 2018, a district court judge invalidated the entire Affordable Care Act after saying the individual mandate made it unconstitutional. The Affordable Care Act did not become constitutional because basically the judge said putting a hold on it pending appeal. The judge said that the mandate that required Americans to have health insurance or pay a tax penalty, which the Supreme Court had said was the reason the law was valid, was no longer there because the tax penalty was reduced to zero. Therefore, the thing that made the Affordable Care Act constitutional was no longer there to keep it constitutional. I'll explain further. So what's the issue? In 2017, the Congress passed the Tax Cut and Jobs Act, TCJA. That was basically known as the big new tax law. It reduced that penalty for people not having health insurance down to $0. It didn't get rid of a penalty, it just reduced it to $0. Well, the Supreme Court found that the Affordable Care Act was constitutional originally after it passed because it was a valid use of Congress's tax powers. So the judge here was saying, well, there is no tax, so now it's not a constitutional law. This month, it's at the Court of Appeals for the Fifth Circuit, so you'll probably be hearing about it this month. Interestingly, the parties to the suit are 20 states that are mostly identified as red states that are challenging the law, and on the other side are mostly blue states, considered usually Democratic states, led by California, trying to defend the law. Now, the Trump administration has said they will not defend the law, so the judge allowed the individual states to intervene and basically defend the law on behalf of the federal government. So if you are seeing a news story and it seems confusing, it's because this has really been picked up by the individual states and it's not being defended by the federal government. So what's going to happen? What's the court going to do? Well, I mean, the court really is going to decide at the Fifth Circuit whether or not the Affordable Care Act continues to be constitutional. No matter the outcome, it'll probably be appealed up to the Supreme Court again. However, if the mandate is considered unconstitutional, a bunch of things could happen. So the Affordable Care Act could be unenforceable. So a lot of those things that came out of that would no longer be required, like protections for pre-existing conditions, those 10 essential health benefits, all of the insurance exchanges, the marketplace, covering your children up to 26, those Medicaid expansion, a lot of the experimental programs, those all could go away, but we're not really sure. It would be a real behemoth of a problem. So as public health students, it's really important to pay attention to what's going on and think about what would happen if the Affordable Care Act went away. Don't forget to check out the exploratory readings this week. They'll probably help you in the discussion post and in your upcoming assignment. And with that, I'm always here for your questions, comments, or concerns. I hope you have a great week 4, and I'll see you next time.